Good afternoon. My name is Paul DeBolt. I'm the chair of Venable's Government Contracts Group. On behalf of BDO and Venable, I wanted to welcome you to the third of our 4 webinars relating to issues and challenges that government contractors face during the COVID-19 pandemic. Today's webinar is entitled The Civil False Claims Act, What It Is and Why Is It Important Under the CARES Act. Joining me today on the panel are Aaron O'Shea, a director of BDO and their Industry Specialty Services Government Contracts Practice, Randy Siebold, a litigation partner here at Venable who has litigated a number of Civil False Claims Act, and Caleb McCallum, one of my colleagues in the Government Contracts Group. The 4 of us appreciate you taking time out of your day to join us, and we hope that all of you are going to stay safe and well. We will try to reserve some time at the end to respond to any questions that are submitted. So Caleb, why don't you give us a quick rundown of the COVID-19 related legislation that has passed Congress?
Thank you, Paul, and good afternoon, everyone. As Paul said, I'm going to kind of give a brief overview of the CARES Act and related legislation and get into kind of just some surface level detail of some things that we think are very relevant as they relate to the False Claims Act and government contractors. The slide you see here is just a brief summary of the pandemic-related legislation that has passed Congress so far. The main attraction, of course, is that third one there, the Coronavirus Aid, Relief, and Economic Security, or CARES Act. This was signed into law on March 27th, 2020, and then it was followed by another almost $500 billion package on April 23rd that added a little bit more money to shore up the Paycheck Protection Program and some of the other aspects of the CARES Act. I think the big point here is that in less than 2 months, Congress has passed over $2.5 trillion with a T dollars worth of spending, and much of that money has already or is getting into the economy relatively quickly. So as you can imagine, the government's going to spend over $2 trillion in a short period of time. There's probably going to be some interest in how it's going to be spent. So I'm going to run through some slides here that cover these 4 aspects of the CARES Act. The first is going to be the Paycheck Protection Program. This has received a lot of media coverage recently, and so some of you may have some familiarity with it. The second one will be the Families First Coronavirus Response Act. This is technically not part of the CARES Act, but the CARES Act made some slight adjustments to it. And then we'll also be talking a little bit about Section 3610 and the related Department of Defense and GSA class deviations related to that. And then I'll briefly discuss a little bit the Title IV lending facilities that also were part of the CARES Act. Please note that each of these is its own complex topic, and I'm only addressing them fairly generally. Venable has considerable resources on its website discussing each of these points, but I do think they will help provide some context for our more in-depth discussion about the False Claims Act that we'll be getting to in just a few minutes. So the Paycheck Protection Program, or PPP, this is probably the best known program under the CARES Act. In very general terms, it allows small businesses to take out up to $10 million loan for quote-unquote payroll costs and certain other overhead and operating costs. There's a formula used to determine the exact loan amount, and up to 8 weeks worth of costs are forgivable. So in essence, if a business handles this correctly, then it effectively turns into a grant. The loan can be totally forgiven. If it's not totally forgiven, they do have to pay it back at a fairly low interest rate. As just an example of potential fraud risk here, most recently there's been a lot of confusion that has arisen regarding the good faith certification required by applicants. So in order to get a PPP loan, you had to certify that economic necessity required you to take this loan in order to keep your business going. There's a great deal of media coverage about publicly traded companies obtaining these loans. Firms with ample liquidity were encouraged to return any borrowed funds. And there's also been a lot of confusion about eligibility more generally. For example, the Treasury and SBA are still releasing guidance on the Paycheck Protection Program. There are questions about how to count employees, how the SBA's affiliation rules apply, what costs are or are not forgivable. You know, this is something that's caused a lot of concern. We'll talk later in the webinar about defenses and how, you know, maybe some suggestions on how to handle these sorts of things. But, you know, as an example, the most recent interim final rule was just released last Friday. It says that borrowers must retain PPP documentation in its files for 6 years. And the SBA essentially reserved the right to review eligibility and qualifications for this program for quite a while going into the future. In addition, the Treasury has already announced that it will review any loan over $2 million. A couple weeks ago, the DOJ announced that it was prosecuting 2 men up in Rhode Island for fraudulently procuring loans under the PPP. So this has received a lot of attention, and I think will continue to receive quite a bit of attention. The next thing I wanted to mention was the Families First Coronavirus Response Act. This was an act that was passed a little bit before the CARES Act, and it generally only applies to businesses with 500 or fewer employees, but it entitles most employees, subject to a list of eligibility requirements, up to 2 weeks paid emergency paid sick leave, or up to 12 weeks emergency family medical leave, which is paid as well. The leave must be taken as a direct result of the pandemic. There's a list of what qualifies as reasons for the leave. Generally, it's if the employee is sick with COVID, the employee has to care for a family member with COVID, or the employee has to care for a dependent because no one else can as a result of closures or COVID. In short, it has fairly complex eligibility requirements, and but the kicker here is that employers can get reimbursed through tax credits for the costs of the leave. So long as the employee's leave is eligible, the employer can receive the tax credits. This kind of interacts with the PPP and some of the other aspects we'll talk about in a minute, and can get a little bit complicated and be another one of these avenues of risk for fraud that we'll be talking about. Real briefly, the CARES Act Title IV provided that the Fed can send up lending facilities and the Treasury will disperse funds under several different programs. The CARES Act appropriated about $500 billion for relief. These are specifically targeted at medium and large businesses. Some of the details are still being worked out. Some of these are actually up and running. Some of the money was set aside for particular purposes. It includes money for airlines. Most relevant to perhaps a lot of people that are listening here today was that $17 billion was set aside to help, quote, businesses critical to maintaining national security. There are going to be some strings attached to this money. There was a report came out, I can't remember if it was last week or the week before, that while some of these facilities are up and running, they actually haven't given out very much money at all in this. So this is still kind of a floating out there as remains to be seen exactly how this particular program is going to play out. And then this is the one aspect of the CARES Act that is directly relevant to government contractors. Section 3610 authorizes federal agencies to reimburse contractors for paid leave that the contractor provides to keep its employees in a, quote, ready state. The reimbursement is supposed to be at the minimum applicable contract billing rates, not to exceed an average of 40 hours per week. And the idea is that the leave should be given to keep employees or subcontractors in a ready state, including to protect the life and safety of government and contractor personnel. Also, this is only supposed to cover the period of January 31st through September 30th this year. Section 3610 itself is only a paragraph. It's just one small section of the larger CARES Act, and it doesn't go into much more detail. Now, both the Department of Defense and GSA have issued class deviations implementing this section. And there's two really important things to know that relate to fraud in particular. And I'm going to cover this on my next slide. You can't double dip. The DoD class deviation specifically addresses this. And also, and we'll touch on this later in the webinar, but the responsibility is on the contractor to adequately document costs and identify credits that may reduce reimbursement. So yes, you can get some of these costs reimbursed, but it's on you as a contractor to maintain the proper records and show the contracting officer that you are entitled to those reimbursements. So this is what I believe to be sort of the main takeaway that I think a lot of people should get from that very surface level overview I just gave. It is possible for a contractor or other business for that matter to qualify for and take advantage of more than one of the programs I just discussed. However, you can't double or triple dip. For example, as I just mentioned, the DoD's class deviation specifically references credit a contractor receives under the Family First Coronavirus Response Act and the CARES Act. And it specifically instructs contracting officers to reduce any reimbursement by the amount of that credit. So if you don't tell your contracting officer about those credits, you could end up recovering more, getting paid more by the government than you should have. And that's a problem. So here's a really, really overly simplified example. So imagine you're an 8A, a small contractor working on a DoD contract. You qualify for and take out a PPP loan to cover payroll costs. And we'll assume those costs you apply that loan to are fully forgivable. Sick leave is contemplated by the definition of payroll costs in the PPP, and you have several employees out because they have COVID or caring for family members with COVID. That leave also happens to qualify for the tax credits under the FCRA. So in addition, it's also possible that those costs are directly attributable to the pandemic under Section 3610 and the DoD class deviation. So in this very simplified example, those costs could be covered by the relief that you as a business have received under the PPP, under the tax credits you're receiving under the FCRA, and you could theoretically claim reimbursement for some or all those costs under Section 3610 and the DoD's class deviation. I'm using this to illustrate a particular point. Contractors and other businesses must be careful not only in making sure they legitimately qualify for the relief available under the various provisions of the CARES Act, but also they understand how those provisions interact. So you can't pay for the same thing more than once, essentially. We will discuss more about defenses and best practices later in the webinar, but here are just some questions to kind of keep in mind and some ideas that are sort of going to be throughout this webinar. What are you using to pay for what? What have you already used to pay for? What does your contracting officer know? Communication is really key here. And what and how have you documented both your justifications and eligibility for the CARES Act programs, and how are you using those funds?
Yeah, I mean, Caleb, I think that's a good point. I think that what you're going to see thematically today is that if you get no other takeaways from the webinar, that documentation and transparency are going to be the key to protecting your business and, warding off any potential Civil False Claims Act claims by the government, because there will be a day of reckoning at some point. Caleb, I have one other question. Are there going to be areas that are baked in for oversight in the CARES Act?
Yeah, and the CARES Act, you can see on the slide here, the CARES Act actually creates three separate specific oversight mechanisms. They're, there's going to be an Office of the Special Inspector General for Pandemic Recovery that's supposed to oversee Treasury and that $500 billion I mentioned under Title IV, $80 million for the Pandemic Response Accountability Committee, which is going to oversee all the appropriated COVID-related spending, so sort of all of this together. And there's going to be a Congressional Oversight Commission, and these are specifically laid out in the CARES Act. And these are on top of all of the already existing government oversight that exists. You know, the DOJ, various Inspector General, auditors, whistleblowers, the GAO, all that stuff that is just normally there. These things are specifically provided for in CARES Act and funded. And so I would imagine that if they're going to create an Office of the Special Inspector General for Pandemic Recovery, and they have $25 million to spend, they're probably going to hire some people and try to look for fraud under whatever their particular, whatever they're looking for.
I agree. So there are going to be a lot of potential traps out there for the unwary, and a lot of people that are going to be coming in second guessing some of the decisions that have been made thus far. So what we're going to do next is do our first polling question. And the first polling question is, do you think the implementation of the CARES Act is going to result in an increase in the number of Civil False Claims Act cases that are brought by the United States government? So why don't we go ahead and open that up for a second and see what our audience thinks. I'm betting yes. I don't know what Aaron or Randy or Caleb are betting, but I'm betting yes.
Yeah, this is Randy. Not only do I bet yes, but I bet it's a substantial increase, particularly given what Caleb just was talking about. There are funded oversight mechanisms that are going to be specifically looking for this, and there's going to be incentive from all the other oversight that existed pre-CARES Act to also be looking for this. So I do think it's going to be not just an increase, but a substantial one.
Yeah, I mean, you don't want to be the auditor that doesn't find nothing, I mean, an auditor's job is to go in and root out fraud and abuse, so, they're going to be looking for something. So let's see what the audience thinks. And boom, 97.5% think they're going to be an increase in Civil False Claims Act cases. Only 2.5% were no, so that's pretty remarkable. So, Randy, sometimes when you have these panels, there's a belief that a lot of this is just sort of theoretical. But I mean, you're going to walk through some cases that actually show how the government will come in and second guess what was done during a time of crisis. So I'm going to turn it over to you.
Yeah, and good afternoon, everyone, and thanks for the opportunity to speak to you all. Yeah, so we don't know, obviously, what the extent of False Claims Act litigation or enforcement that might come out of this will be, but we do know that the CARES Act and the response to COVID-19 has been unprecedented in its breadth and scope. And as Paul alluded to, while we don't know exactly what the reaction will be to this, we do know that in what are now viewed as smaller scale disaster relief circumstances, there has been substantial after the fact False Claims Act litigation. And at the time of the response to Hurricane Katrina, it seemed like a massive response to me, but it kind of pales in comparison to what we're seeing with respect to COVID-19. There are two illustrative False Claims Act cases that I talked about briefly that arose out of the Hurricane Katrina response. The first was United States versus Lighthouse Disaster Relief. And in that case, Lighthouse Disaster Relief contracted to build base camps and house and feed Hurricane Katrina first responders. And after the fact, there was a complaint alleging that they'd made false statements to FEMA by submitting invoices for premature payments, and that they'd failed to build the housing that they contracted to build, that they hadn't built enough housing or the amount of housing that they contracted to build. The litigation that resulted from this lasted well over 3 years. It included discovery. It included motions practice, and there were also extensive settlement discussions. And at the end of it, Lighthouse ended up settling, getting a consent judgment for $4 million that it had to pay. And that was on top of $1.5 million that had already been garnished by the government in the course of proceedings. So 3+ years of litigation, 3+ years of attorney's fees, as well as a judgment of $5.3 million was the outcome. And again, reflective of the fact that the government took very seriously what it saw as improper billing. United States Axrel Jacket Construction Services is another illustrative case from Hurricane Katrina. In that case, Jacket Construction Services had a multi-year contract to maintain and then deactivate FEMA's Katrina facilities. And there was a whistleblower, and we'll talk more later about key TAM actions that are raised not by the government oversight, but by other individuals. And in this case, there was a whistleblower who alleged that the Jacket had submitted claims for work that was purportedly done by a subcontractor, but that wasn't actually done by a subcontractor. And this is another place that people get in trouble in False Claims Act, is that they submit claims based on work that a subcontractor's done and possibly haven't properly overseen the work to know that it was done. The Department of Justice didn't pursue criminal charges in this case, but it did intervene in the Civil False Claims Act suit, but did so 4 years after the complaint was originally filed, and then pushed Jacket to settlement. And we don't know what the settlement payment was, though I suspect it was substantial. It came just months before trial, after both sides had tried to postpone the trial. The court basically said, no, this has been lingering for years and years. This case ultimately wasn't resolved until 6.5 years after the alleged violations and 5.5 years after the original key TAM complaint. So while we don't know what the amount that they settled for was, we do know that there was 5.5 years of litigation costs, attorney fees and otherwise, and it was heavily litigated case. So this is no doubt a very expensive proposition for Jacket to deal with. What can we kind of learn from these examples? Well, I think what both the Lighthouse and Jacket cases reflect is that the government is willing, and key TAM plaintiffs are also willing, to pursue False Claims Act cases for many years if necessary. So, even if it's going to be a tough row to hoe and there's going to be a lot of documentation and a lot of effort that has to go into it, the government's going to take this seriously. In particular, in response to disaster relief, I think the government feels an extra incentive to do so because there's a perception issue with people trying to take advantage of and profit off of this type of disaster relief. So Hurricane Katrina disaster relief, COVID will be no different. There's going to be a particularly negative perception of those who try to fraudulently use this emergency to line their own pockets. But the other takeaway, even assuming that nothing was done intentionally wrong, the government may second guess response efforts by contractors, and that's particularly true after the urgency passes. So focusing on COVID, we all hope that relatively soon and that this will all be kind of a memory or something that we can talk about happening, but that is no longer an immediate and pressing day-to-day concern for all of us. But at that time, it's very easy to second guess the actions that contractors took. And when that's done, it puts the contractor in a very difficult position because actions that they took that were expedient at the time, that expediency no longer is apparent to the government regulators that are looking at this 2, 3, 4, 5 years down the road. The False Claims Act also encourages whistleblowing, and we'll talk again a bit later about key TAM actions, but whistleblowers are not always honest either, and so the fact that the False Claims Act encourages whistleblowing and does so with a large financial incentive leads at times to real honest whistleblowing and at times to false whistleblowing, and this can lead to massive litigation with huge pressure to settle for large sums of money, even where the contractor hasn't actually done anything wrong. And as I kind of alluded to earlier, it's just important to remember that the emergency and urgency of what's going on now is not going to necessarily provide a safe harbor down the road. It's not going to be enough to say, look, it was COVID times and we had to do what we had to do quickly. So yeah, we don't have the documentation we need to demonstrate that this money was properly given to us. That's not going to necessarily be an effective defense. So it's important to take proactive steps now for those who are taking money through the CARES Act to make sure that they're protecting themselves down the road. And I think with that, I'll turn it back to Paul.
Yeah, I think that's a good point. I think the other thing, in addition to being proactive and documenting, what you did with the money, you also need to make sure that the individual or individuals giving you the direction, especially in the context of a government contract, actually have authority. As all of you know that have worked in this space for some period of time, the government's not bound by apparent authority, they're bound by actual authority. And the person that has actual authority is a warranted contracting officer. So you do want to make sure that you're dealing with the appropriate individual that has the authority to tell you what to do with the funds. You don't want to be in a situation where, you listen to the wrong person and there's a fraud claim, or you have to go through some sort of ratification process in order to get reimbursed for the costs that you incurred. So let's talk a little bit about what the False Claims Act is. The importance of it is it imposes civil penalties and damages on parties that submit false or fraudulent claims to the government. As Randy mentioned, a lot of times the government will go after a civil False Claims Act claim rather than a criminal one because the standard of proof is lower and you have the monetary incentive to get people to settle. The Civil False Claims Act has been around for a long time. It's been around since 1863. It arose in the context of the Civil War, where the U.S. government were going after companies that had fraudulently sold supplies to the Union Army. So it's been around in some form for well over 100 years. So there are really 7 situations that a company or an individual can be found liable for committing a civil false claim. The first one and most common one is any person who knowingly presents or causes to be presented a false or fraudulent claim for payment or approval. Think of an invoice, right? There are other ones. Any person who uses a false record to get a false claim paid, situation 2. Situation number 3 is any person who conspires to commit a violation of this act. So you could have a situation where, somebody at your company is working with one of your subcontractors to get monies paid in a fraudulent manner. And they could definitely run into trouble for that. And we do see that from time to time, although it's not common. Situation number 4 is any person who has possession, custody, or control of property used or to be used by the government and knowingly delivers or causes to be delivered less than all that money or property. Typically in our practice, we don't see that very often. Number 5 is any person who is authorized to make or deliver a document certifying receipt of property used or to be used by the government and intending to defraud the government, makes or delivers receipt without completely knowing that the information on the receipt is true. Again, not one you see frequently. Number 6 deals with the pledge or an obligation of debt. Again, not one that you're going to see on a routine basis. And then the last one, any person who knowingly makes, uses, or causes to be made or used a false record or statement material to an obligation to pay or transmit money or property to the government, or knowingly conceals or knowingly and improperly avoids or decreases an obligation to pay or transmit money or property to the government. This is commonly referred to as a reverse false claim. So we're going to spend a little time talking about situation 1. It's the most common violation we see in the context of government contract or a grant. When the courts review this, when DOJ looks at it, if there's an issue, the things that they're going to look at are presentation of a claim for payment to the U.S. government, and we're going to talk a little bit that request for payment doesn't directly have to be to the government. It can be from a subcontractor to a prime who then presents the claim for the government. The claim must be false or fraudulent, and we're going to talk a little bit about that, and then we'll talk a little bit about the knowingly making that presentation to the government. So the False Claims Act does define a claim. It is any request or demand, whether under a contract or otherwise, for money or property, and whether or not the United States has title to the money or property that is presented to an officer, employee, or agent of the United States, or is made to a contractor, grantee, or other recipient if the money or property is to be spent or used on the government's behalf, or to advance a government program or interest, and if the United States government provides or has provided any portion of the money or property requested or demanded, or will reimburse such contractor, grantee, or other recipient for any portion of the money or property which is requested and demanded. So, if there are government funds involved and the government's going to be paying for the activity of the prime or a subcontractor, a grantee, or a sub-grantee, you're going to need to follow the money and see sort of what the exposure is. It used to be, in May 2009, Congress passed the Fraud and Enforcement Recovery Act, which eliminated the requirement that a person had to knowingly present or cause to be presented to an officer or employees of the United States government a false or fraudulent claim. Now, the current state of the law is that FCA liability attaches whenever a person knowingly makes a false claim to obtain money or property, any part of which was provided by the government without regard to whether the wrongdoer deals directly with the government. So this opened up a whole new level of liability for prime contractors and grantees, because now they're going to get tagged with the sins of their subcontractor. So you do need to be diligent in reviewing requests for payments from your subcontractors, your grantees. You probably want to have some certification process in place that the subcontractor or the sub-grantee routinely makes a certification that they're unaware of fraud, that the hours worked are correct, that they're entitled to the money, so that you have some level of protection. Now, having said that, if you do get wind of something going wrong at your subcontractor or your sub-grantee, you just can't rely on that certification. You're going to have to undertake some activity to look behind it and to document what you did to ensure that the monies that are being paid, should be paid. With regard to the claim being false or fraudulent, there's no statutory definition for what's false or fraudulent. It's largely defined by judicial interpretation, or the assistant U.S. attorney or the DOJ person, the IG that you're dealing with, is going to know fraud when they see it. So it's a very fact-based inquiry, and to Randy's point earlier, that's one of the reasons that the cost associated with this type of litigation is so expensive, is it is so factually dependent. Now, knowingly is interesting. When you knowingly present a false or fraudulent claim to the government, and you present a false claim knowingly when you have actual knowledge of the information is false, you act in deliberate ignorance of the truth or falsity of the information, you act in reckless disregard of the truth or falsity of the information, and here's the important thing: unlike criminal fraud, there is no Siena requirement. You do not have to have specific intent to defraud. So if you are not managing your personnel well, if you're not managing your subcontractors well. If you're not doing some sort of due diligence on the bills before they get submitted to the government, you run a risk that you've acted in deliberate ignorance or you've shown reckless disregard. This is not a situation where you as a prime contractor, a grantee, can put your head in the sand. Now, the standard is more than negligence. It's going to be gross negligence, but what the government's going to have to prove at trial isn't the same as what the position they're going to take when you're negotiating and trying to get this resolved. Having been in a number of these negotiations with U.S. attorneys and people from the Department of Justice, when you're in the settlement context, they're pushing it a lot closer to negligence rather than gross negligence, and you just need to be prepared for that. But they're so focused on the potential monetary impact to your company if you get caught up in one of these messes that they're banking on the fact that you're just going to pay them to make them go away, and a lot of companies do that.
Sorry, Paul. I was just going to jump in and say that's absolutely right, and it does take gross negligence for them to prevail at trial, but in my experience, they absolutely don't need anything more than just negligence to bring a case, and they'll do so. And having a case brought against you is a big part of the ballgame, because that triggers all of the costs associated with defending against that, and most of these cases end in settlement. So it's not always important. I mean, it's important to look at what does the statute require them to prove at trial, but it's also important to understand the practicality of what does it take just to get their foot in the door against you with a viable claim that you're going to have to pay a lot of money to defend.
No, I think that's a good point, and I think that to your point earlier that the government's going to be very aggressive in trying to show the public that the money, the trillions of dollars that it is allocated to COVID-19 was spent in the correct way. I mean, I think there was a case in the last 2 weeks where a company in Atlanta had taken a PPP loan, and the money had gone to alimony, cars, and other things, and I guarantee you that individual is going to end up being the poster child, right out of the block. On this slide 26, we have the other elements: intent, materiality, damages. There are some courts require damages for damages to be assessed. The government's not going to take that position because of the fines, and we'll talk about this a little later, that are associated with a false invoice. So, if you get the wrong government attorney that is aggressive, it can be difficult. It can be a challenge. One of the things that there used to be some dispute about was whether a company could get tagged for implied certification. And with the Escobar decision back in 2016, implied certification is here to stay. That when you submit an invoice to the government, you're impliedly certifying that you've met all the contractual requirements and you've done all the things that you're supposed to do. So, as you're taking money from the government under some of these plans in the CARES Act, and you are making a certification to the government, you really do need to understand what you're certifying, because it's going to be very important, because you can get hit for a false certification, and they're going to question, every invoice that they submit. Now, here's a little bit more about implied certification. The view is the claim doesn't merely request payment, but also makes representations about the goods or services provided. I think one of the areas, we see a lot of this is on labor categories that, if there are certain labor categories that are required to perform certain work under the contract and you submit that invoice, the representation is to the government is the people with the proper certs did the work. And if that's not the case, you're going to open yourself up to some false claims. Now, the other thing that was really interesting about Escobar is that there has to be some level of materiality to what you're providing to the government. It used to be prior to Escobar, prior to 2016, that courts didn't really focus on the actual behavior of government employees. The view was that it really wasn't relevant to the tribunal's materiality analysis. But now, and this is something else that, when you're thinking about what you want to document, the courts are going to review government employees' behavior, because what materiality really does is it looks to the effect on the likely or actual behavior of the recipient. So what your company did it really have some impact and prompt the government to pay money that wasn't owed? I mean, some of the things you want to think about and keep note of is, if you submitted a claim to the government, did the government pay a particular claim in full, despite its actual knowledge that certain contractual requirements were violated? If they did, it's probably not material, but 6 years after the fact, 4 years after the fact, 3 years after the fact, you're going to need to have the record to support, your position. The other thing you want to be on the lookout for is, on your contracts, does the government routinely pay a category of claim even though certain requirements of the contract were violated, and you've established this pattern of conduct and they haven't indicated that pattern was going to change? Well, probably not material. Probably not going to be material. Now, what the government has tried to do is that making things material by saying that they're a condition of payment, and the court came down pretty strongly and said that the government couldn't do that. They can't make something material by just saying it is. But again, it's going to be a fact-based inquiry that that the court's going to have to undertake, and that your company is going to have to undertake. And here's just a little bit more on the Escobar case. I mean, I think one of the other important takeaways from the case is that there's a discussion in there that the government can't criminalize sort of routine matters of contract administration, just garden variety contract disputes. And I think that despite that admonition from the Supreme Court, I do think that in this context where there's been a national crisis, that things that probably you or any of us on the panel should believe should be handled as a matter of contract administration, there is still a tendency in the government to criminalize things that you think would just be, just a contractual matter. So, Aaron, why don't you go ahead and talk a little bit about the damages associated with violation of the Civil False Claims Act.
Great. Thanks so much, Paul, and good afternoon, everyone. It's a pleasure to be here speaking today. The False Claims Act was enacted to provide a means of repayment to the government for losses incurred as a direct result of fraud. As such, any action brought under the False Claims Act, the government is the one with the burden of proof on all the essential elements of the cause of action, including damages. The Act authorizes the award of actual damages as well as civil penalties to ensure that the government is made whole for losses caused by these fraudulent acts. A 1986 amendment to the False Claims Act expressly stated that each separate false claim constitutes a claim, and that's very important and something we have highlighted on this slide, that every instance is its own claim and can be assessed penalties directly to it. So that will come up a lot if there's an invoice or a repeatedly invoiced amount that is fraudulent or based on a fraudulent claim. Every time that invoiced amount hits, it could be assessed its own penalty. So this 1986 amendment that expressly stated that each separate false claim could constitute a claim. It also set a range of civil penalties at the time for between $5,000 and $10,000 per instance, as we said. And then in 1990, the Federal Civil Penalties Inflation Adjustment Act was enacted to allow federal fines to be adjusted based on a rate of inflation. Since then, there have been numerous changes to the range in penalties over the years. Most recently, on January 2nd, 2020, the Department of Commerce raised these penalties to be between $11,665 up to a max of $23,331 per claim in civil penalties. As noted here, actual fines can certainly vary between agencies and when the violation occurred. But I think it's interesting to see how quickly things have escalated. You know, we were saying back in 1986, the maximum was $10,000 per instance, but stayed fairly consistent until mid-90s, early 2000s, to now have the minimum be where the maximum was. You know, there was that complete doubling. There is not much guidance on how to determine the penalty amount within this allowable range. The Supreme Court has maintained that district courts have the discretion for determining this amount, and the courts have often differed on how to exercise this discretion. Some courts have decided not to award civil penalties higher than the minimum, in this case at $11,665 per claim, unless the government could justify why it should be higher and up to that maximum amount in the range. Other courts have considered the government expense incurred to investigate and litigate the matter in determining where in the range the civil penalty should be set. Others have considered the gravity of the offense itself. So it's hard to know where in that range anything may fall. There's a lot of discretion out there. In addition to the damages, which we'll talk a little bit more about on the next slide, as well as the civil penalties per claim, the government can also seek interest as well as the repayment of the government's fee to investigate and litigate the matter. The last penalty on the slide refers to kind of a cooperation situation. In May 2019, the DOJ updated the Justice Manual to include guidance for awarding defendants credit who cooperate in a False Claims Act case. The guidelines make clear, however, that partial cooperation credit may also be earned for cooperating with an ongoing government investigation. The government provided non-exhaustive examples of steps companies and individuals can take to earn this partial credit, which may include preserving, collecting, and disclosing relevant information beyond existing business practices, identifying specific individuals responsible for or aware of the misconduct and having some disciplinary action, making relevant officers and employees available for interviews, disclosing relevant facts learned during a company's independent investigation, admitting liability or accepting responsibility for misconduct, or assisting in determining or recovering the government's losses. The guidelines clarify that cooperation does not include disclosure of information required by law or in response to a subpoena or investigative demand. Cooperation credit may be earned, however, by disclosing additional relevant information or proactively aiding the government's understanding of documents. You know, and I think you'll hear all of us kind of reiterate through this not only how important documentation is, particularly now as things are moving very fast, making sure that you have everything recorded, but also cooperation always goes a long way, making sure that you're giving your best faith effort to help the government investigate this, that you want to do what's right by the government. You want to be compliant with your contracts and ensuring that you're doing everything you can to help that. I think the last important thing on the slide, data is suggesting that this cooperation credit, while it sounds really nice and hopeful, and hopefully the cooperation of your company is being looked upon favorably, it's not always applied consistently. There have been some instances where companies who have cooperated fully still end up paying treble damages, whereas others who were not cooperating or did not cooperate as much as one would expect were only saddled with single damages. So there's still a lot of discretion there.
Yeah, I mean, Aaron, if you found, and Randy, maybe you found, is single damages the exception rather than the rule? I think that even if I had a client that was going to help, I'd probably plan on at least paying doubles.
Yeah, Paul, I think that's right. I mean, I've rarely seen single, but I've also rarely actually seen treble, at least in my own personal experience. I feel like the double is kind of more where everything seems to fall.
That's consistent with my experience too, and obviously there's since a lot of this stuff does end in settlements, the pressure of treble is really the key point of the access to treble damages. It creates a great deal of settlement pressure.
Yeah, for sure. This next slide, we're going to talk about trebling damages. So we just discussed how complicated the determination of what the penalty per instance could be. You have that large range. You have different courts finding different things to be appropriate in different circumstances. Same kind of is true for treble damages, double damages, as we were just speaking of, if treble is not really the likely, is how to actually calculate that trebling. There are two generally accepted methodologies, a gross trebling and a net trebling, but please substitute the word doubling in here as well as appropriate. But gross trebling is when damages are calculated based on the total amount paid by the government, and then the benefits received are subtracted after the amount is trebled. Whereas net trebling, you look at what was paid minus what the value received was, trebled, and then treble that. So if you look at the very last two lines here, you can kind of see the impact and how stark the difference in damages could be between whichever methodology is elected. In this case, we're going to assume that the government paid $500,000 for services that had a value of $400,000. If the gross trebling methodology is elected, you wind up having damages of over $1 million, whereas the net trebling, it's about $300,000. And so as I mentioned, similar to the court's discretion on civil penalties, courts also have differing opinions on which methodology to apply. Hopefully it's self-explanatory and understood. The gross trebling method is typically the method advocated for by the government. It's the methodology that's going to result in the most recovery for the government. The U.S. and Department of Justice for the gross trebling can rely on a 1976 decision by the Supreme Court, where the court found that FCA damages could be multiplied before compensatory payments are deducted because that method of compensation most faithfully conforms to the language and purpose of the Act. However, while some circuits have certainly accepted this view and also gone with the gross trebling methods, others have rejected the government's approach in using gross trebling to adopt the net trebling approach, finding that in circumstances where the defendant provided goods or services, the proper measure should be the difference between the amount paid and the value of the goods and services actually provided, since the government, in fact, did receive a benefit of a certain value, less than they paid, but that the company should not be penalized for that by using the gross trebling method. Next slide, we have a matrix of different ways that you could calculate damages. You know, a good question is how exactly do you calculate them? And as we've mentioned throughout this webinar, any fraud intended to cause the government to pay money to pay more money than it otherwise would have falls within the scope of the False Claim Act. And because the Act covers a wide range of potential fraudulent acts, there's no one-size-fits-all measure of damages that would or even could apply to each and every claim. So it really depends on the type of fraudulent activity and conduct that has occurred, what documents exist, what the impact to the government is, and the best way to calculate it. So when considering the best approach to calculate, or really to defend against the calculation of damages that's presented, I think it's important to think of a couple different things. What is the issue? And be specific so you can refine the calculation and focus on that issue. And what data exists, both in what type of data as well as what time frame do you have the data. Sometimes you may not have the full time frame that you need in this case. And in a perfect world where you have everything and you would have every single date and time and there are no gaps in the data, what data would be necessary to analyze the impact of the issue at hand? In reality, you probably don't have that perfect world, so what do you have? What would be valuable? You know, you also want to look at data from the perspective of both the amount charged to the government as well as how to quantify the value received by the government for that product or service. And you also want to think of what data may exist that would help disprove or minimize to the extent possible the damages for the issue at hand. Is there any data that you happen to have that the government didn't have either through firsthand or through the discovery process? Is there something specific about your business practices and processes that is valuable to consider in the quantification of damages that might not be evident right off the bat, and that it would help if you educate the government on those processes and procedures. Are things really as they appear in the documents? Certainly if they're not, it's quite a battle to prove that, but you want to be able to tell your story with the facts of your business, of your case, and of your documentation. So based on the last slide and the fact that every calculation methodology could be different depending on what the fraudulent conduct was, you know, plus some of the data issues, whether there's large volumes of data, missing data, data that's in formats that are non-compatible, that putting them in the right format in order to be able to properly analyze could just be an enormous task that takes time and resources that don't exist. Statistical sampling may arise. Statistical sampling is often used in scenarios where analyzing an entire population is impractical or impossible, where there are time constraints or when a select sample is wholly representative of the greater population. But what about in terms of the FCA? The Act itself does not statutorily authorize statistical sampling, but it also doesn't prohibit it. It's typically more acceptable in the calculation of damages once liability has already been proven. And in these cases, again, it's especially useful in circumstances that we have already discussed where the value add of reviewing each data point is low, where time or resource factors come into play, or when the data just is not available. And while I'm saying that the use of statistics is typically more accepted in circumstances of determining the damages, it's also been accepted to prove liability, again, in these really hard circumstances where the volume of data is just too big, too expensive, and too impractical for the government to run down every single instance to prove the liability. So I'm going to leave it there for now. We'll discuss later on in the next section how statistics could be used in defenses against FCA allegations. But I think now's the time for our next polling question.
Great, thank you, Erin. All right, so our next polling question is, do you think it's appropriate to use statistical sampling as part of the Civil False Claims Act? And so we'll go ahead and give everybody a few seconds to answer that. And then, so what's the panel think? We're going to get 50-50, 60-40 yes? I mean,
I'm going to give that ever famous answer that it depends.
You've been hanging out with lawyers too much.
As somebody who's had it used against me more often than for me, I hope that more people find it inappropriate, but I completely understand the justification for it on the other side.
I think you're going to come out on the losing end of that one, my friend.
I think so too.
Wow, okay. 68% think it's appropriate, 31% don't. That's interesting. Interesting. So Randy, why don't we talk about, we've talked a lot about the potential liability, how various issues can arise. Like, what defenses can companies avail themselves of?
Sure, thanks, Paul. And before I discuss the defenses, I wanted to note for those who are listening in to the webcast and seeking CLE credit, and need a code word for that. The code word for CLE with respect to this presentation is the word fraud, F-R-A-U-D, fraud. Okay. Yeah, so the government's burden is fairly low to establish a Civil False Claims Act violation, but there are several potential defenses. And those include government knowledge, reasonable interpretation, and reliance on expert counsel, and we'll talk about each of those in turn. It is important to note at the outset that successful performance of the contract or achieving the grant's goals is not a defense. So even if you perform well and do exactly what the grant was for or what the contract was for, if there are false claims submitted, that's still there's still a great potential for liability there. So what is the government knowledge defense? The government knowledge defense is basically saying, look, what happened here, the government was fully aware of the circumstances on the ground, and therefore there's this claim, even if it facially appears inappropriate, was not unknown to the government, and therefore there's no FCA action. Most federal circuit courts have held that the government's knowledge of the facts underlying an allegedly false record or statement can negate the requirement that it be demonstrated that you knowingly committed the false claim. And this is, I think, important to keep in mind, but it's also important to note that that the government needs to actually know what's going on in order for this defense to be available. So it's important to be very forthcoming in terms of the information that you're providing to the government. And as we say here, courts have considered a host of factual issues in analyzing the government knowledge defense. The openness with the government about operational problems is one. The fact that government officials are on site, the availability to the government of data demonstrating the operational problems that might be occurring that lead to claims for reimbursement, and the government's knowledge of those problems or the government's knowledge of the violations. And it is important to actually be able to document and show that the government was well aware of what was going on if you're going to try to rely on this defense. The most common circumstance in which the government knowledge defense is used and used effectively is in a contract where the government and the contractor are working together closely and addressing issues that may arise in the course of contract performance and that require a solution that sometimes causes them to agree to go outside the written provisions of the contract to reach a common solution to the problem. In those cases, you can have a very solid defense for any FCA liability that, when after the fact a regulator says, well, you didn't do this right, or you submitted this claim for this and it's not consistent with the contract, you can say, well, we were working expeditiously with the government and they had knowledge all along the way of exactly what we were doing, and in fact, we came up with this solution together. That can be a very strong defense, but again, it really is only effective depending on how much communication and interaction there is with the government, that entity that's responsible for overseeing the contract. The next defense that we'll talk about, or I guess actually a bit more on the government knowledge defense, my apologies. It's not an absolute defense, and it's certainly the case that people raise this defense all the time and say they knew exactly what was going on, and the government responds, well, wait a minute, that's not quite right, and it becomes a very fact-intensive discussion, and for those who hear fact-intensive in the context of litigation know that means the litigation becomes very expensive. But the government can defend itself or negate the defense by saying that its knowledge was not sufficient to understand the falsity, that there wasn't complete communication, or that there wasn't timely communication of the falsity. And as Paul alluded to earlier, it's important to know who you're talking to at the government, because just telling anybody at the government what's going on is not enough. The right person at the government has to have knowledge of the falsity in order for this defense to apply. And so all of this, again, reemphasizes the point that communication is important, and communication with the right people when problems arise or when there are going to be issues with submitting invoices that might not conform to the specifics of the contract. That all is information that should be conveyed to the right people within the government and discussed proactively on the front end, as opposed to trying an after-the-fact justification for your actions. In the specific context of the CARES Act, I think this may actually come up quite a bit, just because, just to give a simple example, the costs allowed under Section 3610 of the COVID Act and the Department of Defense and GSA class deviations depend in a large part on approval by the contracting officer and clear communication with the contracting officers. And, you know, based on how the statute is written and also just on what we've just discussed about the government knowledge defense, the more that you disclose, the more you document, the less likely it is that on the back end you're going to be subject to liability for not being forthcoming, and the more likely it is that you're going to be able to use this government knowledge defense to protect yourself from False Claims Act liability. The next defense that we'll discuss is the reasonable interpretation defense. And this basically is where parties' reasonable interpretation of an unclear or ambiguous statutory provision or regulatory provision, if you're acting reasonably and your interpretation is reasonable, that may, and I emphasize the may, negate the knowingly or reckless disregard standard for FCA liability. It's also the case that a plausible contract interpretation, if a contract is ambiguous, may negate False Claims Act liability, even if it's proven incorrect. There is, however, I guess it's important to emphasize the may here. There's definitely dispute among the courts about the extent or possible limitations of this defense. And it is also the case that this will not work as sort of an after-the-fact creation for purposes of litigation. Several courts have been pretty clear about that, if a statute is ambiguous on its face, but there's a known sort of industry standard interpretation of that, going in a different direction that's contrary to standard practice, just because you could plausibly read the statute that way, is not as likely to provide you with a viable defense here. Courts actually look to the fact that, or look to see whether your justification that your approach was reasonable under the statute, regulation, or contract, whether that was how you were proceeding from jump, or whether that's a manufactured, post hoc rationalization with, intended to get you out of liability for actions. And obviously the latter is not only disfavored, but can really come back to bite people. So in short, you can't just find some arguable ambiguity in a provision of the law or the contract and hope that that's going to give you a free pass if all other information is telling you, or standard practice is telling you, that it should be interpreted a different way. The last defense that I want to discuss briefly is reliance on expert or counsel advice. And the expert advice defense is available, but as the first bullet notes, it's available where full disclosure of facts has been made to the expert. So you obviously can't cherry pick the information you provide to an expert and then rely on that expert's opinion to protect you. The advice of counsel defense is similarly available. The issue there that often causes heartburn for folks who think they may want to raise it is that it's going to require waiving attorney-client privilege, and that's not typically going to be a targeted waiver of just the information you need to rely on with respect to your advice of counsel defense. It's almost always, there's almost always going to be a push to broaden that waiver and make sure that everything else that you were talking about with your counsel wasn't somehow contradicting that, which potentially opens you up to, again, as any waiver of attorney-client privilege might, it opens you up to any number of other issues that are often very concerning to folks considering relying on this defense. I think these defenses, and particularly the reasonable interpretation defense and the reliance of expert or counsel advice defenses, are relevant to the CARES Act because the CARES Act is written very quickly, and in an emergency situation, there's very likely, I think people have already identified, or some have already identified, some ambiguities in the Act, and certainly I have no doubt more ambiguity will be identified over time and as add-on legislation comes in. And the guidance that's come down and regulations that are coming down are often a bit opaque, not entirely clear. So I think that there are going to be circumstances of justifiable, interpretations that people have to make in an emergency situation. And after the fact, the government or regulators are going to say that's wrong, and we think about it a different way, and this is going to be a very viable defense. Relying on experts or counsel will be helpful in that respect. Making sure you document that will be helpful in that respect, and making sure that you're documenting the basis for your actions along the way. So if you're acting in a certain way in the face of ambiguous guidance from the government, make sure you're documenting what actions you're taking and why you're reading the statute or the regulation or the contract the way you are, because that'll help demonstrate down the road, if need be, that it wasn't an after-the-fact justification for your action. So with that in mind, I think Erin is next going to speak about statistical sampling and its utility with respect to defenses.
Great, thanks, Randy. And I'm going to talk about the statistical sampling defense kind of from two perspectives. One, what if the government uses it? What are your defenses against that? And two, what if they didn't and they should have? And in the first case, again, just to reiterate, we've been saying that statistical sampling can be necessary in certain circumstances if there's not enough time or resources to do the full review, if the population of data either isn't there or it's voluminous, missing time periods, that sort of thing, or if the data formats or the quality of the data that exists is so poor, it would take so much time to get that without that value add. Folks may rely on statistical sampling. So if the government's presenting the damages numbers using statistics, what can you do? I think it's important to know what data you do have. I think it's important to understand what the government applied in terms of its sampling process. How big was its sample size? Is the sample size that's selected reasonable? Is it a representative sample size of the full population? What confidence intervals did it apply? Why did it use statistics versus doing a full evaluation? And I think another thing too is if statistics were used, do you as a company have the resources and the time available to do the full review? Whether that's involving internal resources, engaging outside counsel or external consultants to help you in the analysis. It sounds costly and it sounds time consuming, and it likely is, but I've been involved in a number of matters where the damages presented were in the tens of millions, and when we looked at all of the results, specifically not based on a sample approach, we really found that the true damages that should have been applied were much smaller, and that delta actually made up the payments for all the external resources and the internal resources to do that analysis. Another example I have, one matter I was involved in, there was an allegation that there was time charging issues where managers were telling the employees what projects to charge on in advance of their work, and it was all verbal. So in other words, there was no data to support and kind of trace through the history of what happened. You would see the timesheet and its final representation, which was apparently dictated by the project managers, and the employees were told which projects, specifically which government contracts to charge on. So in that case, the government came in and said, therefore, on all of these projects that these managers worked on, we want all of the revenue that you earned back. What we were able to do through a combination of employee interviews and statistical sampling in order to try to prove the negative was to show that it was not as was alleged. It was a language barrier issue that caused the misconception, and that those time charging issues were really on an individualized basis. But we could only prove that through the additional work that we did and through the statistical sampling that we, outside counsel and the company themselves, kind of engaged in order to prove that statistical sampling was the only way, the data wasn't there, but also just applying this blanket, therefore all revenue should be paid back, also wasn't appropriate. So with that, Randy, I believe it's back to you with key TAM actions.
Thanks, Aaron. As we alluded to earlier, the other issue with the False Claims Act is that it opens up, it allows private individuals to seek, to file claims, to file false claims. And what that means is that it's not just the government regulators and the government oversight that's going to be looking for potential false claims, but it kind of opens it up to everybody, and there's quite a bit of incentive created within the Act to those who would be whistleblowers. And one of the problems we see, obviously, with that type of incentive is that it's not just the good-hearted and the right-minded individuals who really see problematic actions by government contractors and raise False Claims Act claims as key TAM relators, but it's also people who have their own self-interest involved and sometimes do it inappropriately. But under the False Claims Act, a private individual can raise a claim. The government then has authority really at any time to intervene in the action, which means that the government steps in and takes primary responsibility for pursuing the claim that was raised by the individual whistleblower, or the government can decline to intervene, at which point the private individual can continue to litigate the case on their own, and that has responsibility for doing so. The government, and we'll talk about this a little bit more in a couple of slides, but the government also has the authority to step in and dismiss or settle an action, and there's some further guidance, fairly recent guidance on that issue. So I think with that in mind, we do want to go to our next poll question, Paul.
Thank you. So here our next polling question is: I'd probably say who is the most likely whistleblower? Former employee, current disgruntled employee, subcontractor, outside consultant, or advisor. So why don't we give everybody a chance to take a look at that and see what the survey says. What are you guys thinking, the panelists?
Yeah, I realize that this is not a real answer because we kind of want to see how folks distinguish among these in terms of probability, but all of the above. I've seen them all.
Yeah, I have too. I mean, I've even seen people that their outside counsel end up being a key TAM relator, and you're like, wow, thanks for that.
Yep.
All right, well, this is interesting. I'm going to push this out. Let me see. Push to audience. That should be up, right?
Yeah.
Okay.
Yep,
okay.
Got it.
Current disgruntled employee, 55%. I see it a lot with the former employees. A lot of times when somebody gets fired for performance-based issues, they want a bigger severance package. They send a letter in from their employment counsel, and the last paragraph says, oh, by the way, my client may also be aware of some fraud, just so you know, which kind of really limits your ability to settle because you can't pay to have a fraud claim go on. Subcontractors, interesting, not particularly suspicious. And hey, you know what? Looks like the outside consultants and lawyers and advisors are trusted, so that is a good that's a good thing. All right, there's a couple other I guess key TAM slides and sort of the how the monies are awarded. So Randy, I'll go back to you.
Sure. Yeah, and the important thing here is just to understand the incentives created by the False Claims Act. If the government intervenes, the relator, whistleblower in a key TAM action can still receive between 15 and 25% of the proceeds, although the courts have some discretion there. And if the government does not intervene, that amount can be higher. But there is this great incentive, and by great I mean substantial incentive for key TAM complaints that can really kickstart often the government to jump in and pursue a claim further.
I think the other thing too is that. Oh, go ahead. I'm sorry.
No, please go ahead.
No, I think the other thing is that people don't realize a lot of the attorneys that take on these QTAM cases do a contingent fee. So there's not going to be a great cash outlay for a former employee to pursue this type of action because a lot of these people treat it like a personal injury claim.
That's right. That's right. There have been changes, or in 2009 there were some changes under the Fraud Enforcement and Recovery Act that affect the QTAM action. The first, I think probably the biggest one is Bullet 2, or at least the biggest from my experience, which is that the authority to issue civil investigative demands has been broadened, and so it's no longer that difficult to do, and therefore they are issued a lot more broadly, and the information that has been gleaned from those can be shared then with relators or state or local law enforcement, which I think has broadened the not just the number but also the sort of strength of QTAM cases. The fact that the government can intervene and either dismiss or amend the relator's complaint, for a long time, it certainly was not the case that the government would regularly intervene and dismiss these cases or narrow them. But in January of 2018, there was a memorandum issued in the Department of Justice called the Granston Memorandum, named after the person who issued it within DOJ, which made clear that the policy of DOJ now is to really take a hard look at QTAM actions and to intervene and dismiss those actions when they're deemed to be inappropriate or not in the government's interest. And as I understand it, again, this is a relatively new policy, but as I understand it, it actually has been used somewhat robustly. I think the claim from the Department of Justice in a January 2020 speech that was given was that in the 30 years preceding the Granston memo, there had been something like 45 cases in which the government had intervened and dismissed a case under this authority. And in the 2 years that the Granston memorandum has been in effect, there have been another 45. So it's basically doubled in that short period of time. But what the memorandum did is it basically established an internal policy for assessing QTAM actions that were pending and stepping in and getting rid of them where appropriate. I think that's important to realize because it's sort of a pendulum swing from the 2009 changes that made QTAM actions easier to bring. I think the assessment was, wait a minute, we're encouraging this maybe a little too much, and there are a lot of meritless QTAM actions out there, and we need to get rid of them. And that Granston memorandum identified a number of bases on which the government can and should step in and dismiss QTAM actions. And these include curbing meritless actions, preventing parasitic or opportunistic QTAM actions, and also just protecting the DOJ's litigation prerogatives or protecting the government's own interests, including the resources that the government has to spend monitoring even those QTAM actions in which the government doesn't intervene. So we'll see how that plays out over the next couple of years to see whether continues to be a move away from QTAM. And with that, I'm going to turn it over to Caleb, I believe.
Thank you, Randy.
Thank you, Randy. Just real quickly, something that government contractors hopefully are already aware of, but definitely need to be aware of, is that the so-called mandatory disclosure rule is incorporated into your government contracts with clause 52.203-13. This clause specifically incorporates the Civil False Claims Act. In relevant part, it states that the contractor shall timely disclose in writing to the relevant OIG with a copy to their contracting officer whenever in connection with the award, performance, or closeout of this contract or any subcontract thereunder, the contractor has credible evidence that a principal, employee, agent, or subcontractor of the contractor has committed a violation of either the criminal code of the United States or a violation of the Civil False Claims Act. So this is very important. This essentially, as the slide says, is a mandatory disclosure. If you're aware of a violation or a suspected violation of the Civil False Claims Act, you have to report it. As I mentioned, the disclosure has to be made to both the contracting officer and your respective Office of Inspector General. The principle is pretty broadly defined. Any officer, director, owner, partner, or person having primary management or supervisory responsibilities. Another thing that comes up a lot is that there's no definition for timely or credible evidence in the rule. When the rule was first created back in 2008, the preamble in the Federal Register said that with regards to timely, that, quote, until the contractor has determined the evidence to be credible, there can be no knowing failure to timely disclose. So this is basically, what this means is that if you catch wind of something, you do have a period of time where you're supposed to do an internal investigation, determine whether that evidence is credible before you disclose it. And okay, fine, so you have to disclose. What does this mean to you? Well, it means that if you don't disclose it, the penalty is suspension or debarment, which is really not good for a government contractor. So that's the mandatory disclosure rule, something very important and very relevant here because it specifically incorporates the False Claims Act and requires you as a government contractor to disclose any violations that you are aware of. And I believe we have another poll question now.
We do, Caleb. Okay, true or false, there's a de minimis dollar value exception to the mandatory disclosure requirement to disclose fraudulent billing. So we'll just take a little bit. Couple seconds. Let's see what we get. Oh, interesting. Okay. Well, let's go ahead and give it another second or two, and then we'll wrap up the last slide we have. So let's just go ahead and push it to the audience. So that should be up, and 26% think it's true, and it's actually false. There is no de minimis exception. I've had to do mandatory disclosures for time charges or fraud for as low as $2,000, and I reached out to the DODIG and said, hey, do I really need to do this? There's not much at stake, and the answer was there is no de minimis exception, disclose it. So it's pretty interesting. All right, so Aaron, if you could just walk us through in the couple minutes we have left, just some of the particular problem areas that you've seen, based on the work that you've done, that'd be terrific.
Yeah, of course. So this first slide kind of summarizes the main things, and these are areas that not only the contracting officers in the government is going to be looking into, but also that you should be looking into internally and doing compliance sweeps to review for potentially sloppy timing mischarging, sloppy time billing fraud, just looking at defective pricing, especially if you have GSA schedules and commercial sales practices associated with it. I mean, I think the important thing is to make sure that your folks are aware of what the regulations are. They are trained on the correct policies and procedures that your company wants to follow for all of these items and the correct steps to take if an issue is identified. In terms of cost mischarging, I think I see it most frequently in terms of labor mischarging, whether that's ghost hours, the recording of hours for either a person that didn't perform the work, time that was not actually worked, or even junior level individuals billing at higher labor rates in order to qualify for more labor dollars, changes in unallowable costs, and maybe not doing the sweep, not catching them, or knowingly putting some of those unallowable charges through there and then not catching them and repeatedly invoicing the government at those indirect rates, as well as crosswalks of internal resources to make sure that the folks who are working on your job are qualified at the levels that you are in fact billing them in, and making sure again that you're doing those internal sweeps, documenting these issues, doing the mandatory disclosure if something is found, even if it's that low dollar threshold that Paul mentioned, you know, just making sure that you say, hey, we identified this, we're quantifying it, we are aware and we're fixing this. Slide now is some things in terms of product. It could be Buy American or specific domestic product preferences, falsification of test documents to say that, yes, of course I did the inspections and everything's good, or using documents of other testing and inspection reports on a product that wasn't actually tested or inspected. And I think just some red flags, again, it's very important to do the training, the internal sweep, as well as make sure all of your employees have either a peer-to-peer review or a manager that is responsible for their review, and they're not the sole one responsible with something and possibly getting direction from either someone more senior who may have other ideas of what they should charge to be successful that may not entirely be right, but just making sure that you have the second set of eyes on everything that's happening. Oh, sorry, I think I went too far. I guess we have one last polling question. Paul?
Yeah, let's go ahead and do that. So what areas under the CARES Act do you think that a civil false claims violation is most likely to occur? Failure to properly allocate costs among CARES Act programs, time charges, double recovery, labor and material charges, just misuse of CARES Act programs. Why don't we go ahead and see what the results show, and then we'll wrap this up. What are you guys thinking on the phone?
I think double recovery. I think there's complicated multiple programs, and I think double recovery is going to be a big issue.
Yeah, I think we're going to see it there, as well as the properly allocating costs among the CARES Act programs.
Huh.
Agreed.
Well, you guys were very prescient. The survey says double recovery. And I think there is going to be a lot of risk for that. So last couple of slides, we're not going to spend a lot of time on. They're just sort of practical tips that I think that contractors ought to follow. You know, you need to have a compliance program in place. Make sure you follow it. Make sure you know your contract, so you know what you're doing and what you're not supposed to do, what is a certification, what isn't. If issues come up, raise your hand. You need to be transparent with your customer. And, you know, don't over-certify to things. If there are things that you do not have to certify to under your contract, don't, because you don't want to take on some additional obligation that you don't have. So we're just a little bit over 90 minutes. You know, thank you so much for joining us. I thank you to the panel for being here today. We have another presentation coming up the 2nd regarding mandatory disclosures, but we do appreciate everybody hanging with us today, and we hope you found the webinar informative. And thanks again to my panel. You guys were great.
Thanks all.